Hey, hello and welcome. It's 12 o'clock. So the main stage is now live again, I hope. Exactly. I can now also see it on my tab. So hello and welcome everybody that's coming back. We'll give you a minute or two, or give everybody a minute or two to join Irina and myself. So Irina has made it. As you see, we've been able to solve the problem in the background. I'm really glad about that. And we now have enough hour to talk about the European Commission's proposals around rules and actions for AI. So my understanding of this is that actually it comes in two parts. So actions, of course, means that the European Commission would like to support the adoption of AI so that it gets used more, and also have projects that look at what excellence means in the field. So there's this element of actions, and then there's also the element of rules. And the element of rules, of course, is about, in some sense, regulating AI. And something that I noticed is that what does rules mean? That the European Commission has been working on risk and risk assessment for use cases. But what I would like to do, actually, Irina, so hello and welcome. What I would like to do is I would like to ask you to introduce yourself a little bit to the audience, so who you are, where you work in the European Commission, and then move on to give us some background on this rules in action for AI. Also because, you know, it's really recent, and just last month, at the end of April, the European Union really announced a series of measures and proposals. So Irina, over to you. And for the audience, if you have questions, please use the chat. Irina, your turn.
Thank you very much, and I'm very happy to be here. I'm even more happy after the problems I had to connect. And so yes, my name is Irina Orssich. I have been working with the European Commission for a long time, and actually next week on 1st June, I have been working for 3 years on artificial intelligence. Now, we, the Commission, we have been supporting research in artificial intelligence for the last more than 15 years, but we only started around 3 years ago also to work on the policy side of it. And all this started in April 2018 with a communication on a strategy for AI for Europe. And already there we said what Chris just said, that we see several sides of AI. Our baseline is always AI is good. AI is good for citizens. It's good for business. It's good for the public interest. It can help us with public health, with environment, with more or less everything. But indeed, it also bears certain risks for the safety and also for fundamental rights. So this has been our position from the beginning. There was, in the initial communication, there was a third pillar on the future of work and the societal challenges, but that is something I will not talk about today, but I will talk about the trust part, so the risks to fundamental rights and safety, and mention indeed that we also work on the excellence part. So that is the spirit in which on 21st of April, we have adopted the big AI package with the revision of the coordinated plan. So the coordinated plan is a joint undertaking between the Commission and the member states, really to push artificial intelligence forward, to have strategies which are synergetic, to create the right environment in terms, for example, of data, of skills, of computing facilities, of the economic environment for companies to invest, and last but not least in research and the transfer into the market. So this is the excellence part, and then there is the trust part, and that indeed is the proposal for the Artificial Intelligence Act. So the proposal for a regulation. Why we are doing this is, first of all, we believe that we already have a very comprehensive legal framework in place. We have the fundamental rights, we have safety rules, we have data protection rules, we have anti-discrimination rules, we have consumer protection rules and everything. But then AI has certain specificities, and you all will know that much better than I do, with regard to opacity, with regard to a certain unpredictability of outcomes, with regard to autonomous learning and autonomous results, and also with regard to data and bias, where we believe that it's difficult to assess how the existing legal framework can be applied to artificial intelligence. And there are some uncertainties, insecurities of companies or other stakeholders, people developing AI, like how does this apply to us and what is the consequence if there is an issue? And this is actually the gap we want to fill with this legal framework. So we want to have really a tailored regulatory response to those uncertainties, to say, how does the legal framework apply to AI? What does this mean if you develop an AI? So that's a bit the background of what we are doing. And perhaps just one more word on European Union works. So the Commission proposes a legal framework, and that does not mean at all that this is going to be enacted at the end the way we proposed it. But we have something which is called the co-legislation procedure with the member states and the European Council and with the members of the European Parliament, where both discuss the draft legal act, make proposals for amendments and for changes, and at the end, the three of us, so the Council, the Parliament, and the Commission, will try to combine the different elements and to propose a final text which then could be adopted. And this probably, if really things go like rocket-wise, it could be at the end of the year or like in a year from now, but that would be very dynamic. So it could take longer, and then there is still some transition periods, just to put it also in a certain time frame.
Okay, thank you, Irina. So I understand that we're looking at a longer process, but there are also some proposals on the table, so to speak, in terms of rules. And something that I noticed in looking at them is that they emphasize risk and risk assessment for use cases. And the categories that the European Commission is using is minimal risk, limited risk, high risk, and unacceptable risk. And actually, for anybody watching us, if you then later want to use your search engine and find it, and we'll also post a link, so we'll make sure you get an overview. But our real chance with you, Irina, today is to ask you to kind of tell us a bit about these risk categories and what they mean and what you have in mind and how this is going to work. And my suggestion would be that we start, so to speak, with the minimal risk. So in the eyes of the European Commission, what are use cases that carry minimal risk, and what do you plan to do about this?
Yeah. So perhaps just as a little forward, that we indeed don't want to regulate the technology. We don't want to regulate AI as such. But what we do want to regulate are use cases, individual use cases. And now you have to imagine the whole thing as a pyramid. And at the bottom, you have the cases where we say there is minimal risk or there is no risk. And for these cases, we don't foresee any regulation. So where we find that there is no specific risk, there is no legislation foreseen, and the existing legislation will continue to apply. What we would like to encourage on these cases is the use of voluntary codes of conduct, like, for example, by chambers, by associations. Many of the bigger companies already have established codes for the ethical use of AI in their companies. And also, we did work with a high-level expert group on artificial intelligence. They established an assessment list for ethical, trustworthy AI, which is very concrete. So you can do that on the internet and really fill in the specificities of your system And from there, you will get like some hints about what is how trustworthy, how ethical. So all this we want to encourage, but there is nothing compulsory in this category. And then I don't know. No, sorry, you're looking at the question.
Yes, no, okay, understood. Actually, my suggestion would be to move up and look at limited risk. And I would then actually leave it to the audience. So dear audience, if you want further, if you have comments on this, or you want further insights into what minimal risks is or think it through, please use the chat to ask a question, but we move on to limited risk.
Okay, so the limited risk is, let's say, more a specific risk. We believe that there are certain applications which deserve specific transparency rules. So, for example, if you are dealing with an AI, with a chatbot, or also if we now have this like an AI calls you, we believe that people should be aware that this is an artificial intelligence. The same is with some exceptions if there are deep fakes. So deep fakes indeed you might use for certain artistic reasons, or there might be certain public interests when it comes to law enforcement. But in general, there should be like a label, this is a deep fake. And the same applies for emotional recognition or biometric categorization systems. So here the one and only requirement on these systems is on what we propose is on transparency. This does not exclude that one of these systems could also be in the high risk category. So it might very well that a given system falls under both categories and needs to be transparent and to fulfill the requirements I'll be talking about in a minute.
Can you say a few more words on what transparency means?
Transparency means really like I tell you, I'm an AI, I'm a roboter, I'm not real. That's it.
Okay.
And indeed, if you use a system like Siri or Alexa and you use it every day, it's not that every day you switch it on, you will be told, hello, I am not real. But this is really, if it goes without saying, it goes without saying. So it is for the situation where you don't necessarily expect this.
Okay. Thank you for that. Then let's move on to the high risk.
Yeah, actually, here we are really at the core of the legal proposal. So these are the use cases we do want to have, like the real regulation. This is why we are doing the regulation. And so what is important to know for these high risk cases is we would impose certain requirements on them. These requirements would apply before the systems are put on the European market or used on the European market. So it's not that each user who wants to use a certain AI needs to do 500 things, but the requirements will be essentially on the provider of the AI. So it will kick in at a pretty early stage. We have different groups of products or services where this applies. The first one, and that is relatively easy, we already have a number of products where there is a conformity assessment, so where there are certain safety requirements, safety standards. For example, for cars, for planes, for machines, for all kinds of things, for health products. So there, the safety of the product is already checked before the product is being put on the market. And we want, where these products include an important AI component, which indeed has an impact on the safety of this product, we want the existing conformity assessment, the existing safety check, to include the AI component. Is that clear so far? I'm just looking at you, and your face is a bit question mark.
Exactly, my face is a question mark. I've been following it and trying to think it through, and one can think of some of the obvious use cases that come to mind that are publicly well known, like autonomous driving. Maybe also actually medical use cases where an AI is involved. And risk in this sense also means that it impacts people, it potentially impacts lives. There's also actually potentially, of course, the issue that something goes very wrong. So this has always been discussed for autonomous cars. What do we do if an autonomous car accidentally kills someone? Or if you have a medical treatment that is then unsuccessful. These kinds of things. But while I was following you, what I was curious about or interested in is that you said that if it's high risk, the producer, so to speak, the person or the company developing the product has an obligation very early on to kind of look at these issues. And then what do? They're supposed to meet certain kinds of requirements. They document the process. So what is your thinking, what they are expected to do?
Actually, I wanted to come to that a bit later when I told you all the different risk categories in the high risk and products. But they normally have to do a conformity assessment for these products. So this is something which is already required, and we are here only talking about the products where it is already required. Yeah.
Okay.
And this.
Conformity assessment. I'm just thinking of, so something that everybody now knows because it's a new product is these electric kick scooters that you can now rent and drive around or buy. And they also had to undergo a conformity assessment, right? So this is what was done for, if you wanted to rent or sell kick scooters on a national market, there are certain regulations and you have to prove conformity to these regulations. That's what that means.
Not necessarily. It's like imagine you are a builder, you are constructing such a scooter, or you're constructing a car. Before you put it for the first time on the market, so not like about the national regulations how to rent it or whatever, but this is really like a technical control. So to see whether the product is safe to be put on the markets, whether the brakes work well, whether I don't know what for the scooters.
It respects, in this kick scooter case, the speed limit, the brakes need to be there, the safety features need to be looked at.
Exactly.
The battery needs to be safe.
Exactly.
Yeah, these kinds of things. Okay, I think this way the audience can imagine this. And so if you have a product that's AI or AI in the product, you kind of also need to do this conformity assessment. And this means there will be an authority that checks up on it. Because, for example, for the kick scooters, right, there's then national regulation, and there is an authority that every kick scooter, every line of kick scooters you want to sell on the market, you need to actually prove the conformity and get the okay from the regulator, and then you can sell it.
Exactly.
Okay.
And it's exactly that authority which now should also, because they know the product, so they know it very well, and this authority should then also check the AI components of it. So let's assume the brake has an AI component. We will not have one test with the authority which currently does the scooter and a second one with an AI authority. But the scooter testing authority should then also get the knowledge about the AI components within the brakes, because they already have the knowledge about the brakes, and include that check in the existing examination of the thing. Before then, it receives what is called a CE label, and with that CE label, it can be marketed.
Okay, understood. I hope the audience has understood it as well. The risk category that we haven't looked at yet is unacceptable risk.
No. Wait. We are far from having finised with the high risk.
Okay.
I'm sorry.
Okay, fine. That's fine. It's fine to stop me.
Actually, this was only the part of high risk where we already do have safety regulation, and conformity assessments.
Okay.
But more importantly, at least to some extent, there are many many AI products or services which are at this point not subject to any control, to any requirements on the technical side. So there is at this point no such thing as a requirement or a conformity assessment, yeah? We call them like standalone systems. And here what we did, and these are the new risks we see, where we believe that they also need to play by certain requirements. So what we did is that in the legal framework, we were talking about 8 different fields in which such use cases to be regulated could appear. So it's not the entire field, it's only the use case. In the legal act, you have the field and you have an annex which tells you about the use cases. The reasoning behind is that we believe that since we are dealing with a very dynamic technology, there can be many, many use cases in 10 years we wouldn't think of today. So we want to be able to adapt that annex without too much of a legal procedure. And I just told you about our current procedure. So to avoid lengthy procedures, we want to be able with a shortened procedure to adapt that annex to any technological changes we wouldn't think of today, probably because they just didn't happen yet. Yeah? So we have the 8 fields and the applications. For the fields, the first one is, and that's also the most controversial one, which we will see again when it comes to prohibitions, is biometric identification and categorization. And in that field, for now, we consider as risky only the biometric identification. Okay? Biometric identification of natural persons, be it real time, be it post. Then we have, as a second point, we have the management and operation of critical infrastructure. Here, what is currently in the annex are things like road infrastructure, traffic, water, gas, heating, electricity. Then we have a third group which comprises education and vocational training. Here it's about the access, so the access, for example, to university or to a certain school, but so it's about the admission tests, but it's also about the monitoring of exams. Then we have a category employment. This is about recruitment algorithms, and it's also about the monitoring of the employees. We have access or enjoyment of public and private services. Private services, here we have the credit scoring. Public services, we have the evaluation of social benefits. Then we have a number of use cases, and this is probably less interesting for you, in the field of law enforcement, in the field of migration, asylum, border control, and in the administration of justice. So these are the 8 fields with the use cases. And there, at this point, everything I told you before about the products, there we don't have yet such a thing as a conformity assessment, which means that this needs to be done. Now, for all these 8 fields, except for biometric, it will be a self-assessment by the provider of the system, which means that there are certain requirements. I'll come to them in a second. They need to fulfill, but they can do a self-assessment. Then there will be also post-market monitoring. There will be a certain surveillance, but a priori, it's not like in the products that there is an authority doing this, but you can do it yourself. Exception biometrics, this very, very controversial. There we are also going to have a third-party conformity assessment. Now, the story about the third party for the other 7 fields can be changed. There we also see and foresee an easy legal basis in the Act if we see that it doesn't work with self-assessment, that there could be also a third party assessment. But this is something we would rather like to avoid. So then the next question most likely is going to be, what are the famous requirements they need to comply with? And yes?
Yes, indeed. So on the one hand, I'm actually looking at the clock. We have 5 minutes left.
Sorry.
Yeah, that's fine. We spoke earlier, so I think that this exposition is important. I think it's important that we hear it. This is happening over the next years. So if you would like to say something a bit more about the high risk and the requirements, that's fine. I'm just going to make sure that we have 2 minutes left to talk about unacceptable risk.
Okay, no, it's easy. So we have 5 different requirements. They regard the quality of the training data, validation and testing data, very important to avoid discriminations. Then that when developing the system to establish a certain documentation and certain design logging features in order to ensure the traceability and the auditability of the system. There should be a certain information to be passed on to the user, like you're going to the pharmacy, you're buying pills, you're getting like the little paper with indications, counter indications, what to do, what not to do. So this would be handed over to the user. Then there would be certain mechanisms on human oversight. Indeed, there would differ, let's say, from credit scoring or an employee recruitment algorithm or a self-driving car. And then there is a requirement regarding robustness, accuracy, and cybersecurity. And for all these requirements, indeed, we will start the process, kick off the process of standardization soon, so that they don't stay there like very abstract, but that there will be standards, industry will be indeed participating in the standard making, and that these can be easily implemented. So just one more word. So most of the obligations, as you say, are on the provider. There will be only few obligations on the user to deal with the AI in line with the instructions, and if ever there is a problem, really to monitor that and to communicate it. And that would be it about high risk.
Okay, thank you very much, Irina. Well done. We have exactly those 2 minutes left. So my final question is actually on the unacceptable risk. And does unacceptable actually mean that it will be prohibited?
Yes. Yes.
Okay.
So they're very. So we only have 4 different groups here. So there are certain manipulation practices and the exploitation of children or mentally disabled persons, very important, both leading to psychological or physical harm, not to loss of money. Then we have the general purpose social scoring, so the Chinese systems by public authorities. This would be prohibited. And then we have, with certain exceptions, remote biometric identification in real time by law for law enforcement purposes in the publicly accessible space. So this would be prohibited, but with certain exceptions. For example, if there is a terrorist threat, or if you're looking for somebody who is very, very criminal.
Okay. I counted 3. Was there a 4th one?
Actually, no, I took the first 2 together. So we have the subliminal manipulation, and we have the exploitation of children and other vulnerable persons.
Okay, understood. So that gives us the 4. Okay.
I'm sorry to interrupt.
Yes.
I just want to mention that we do have some questions from the audience, and I would like to address them.
Yes,
so
please.
One of them is about how to mitigate on the risk of over-regulation. And related to that, tech moves really fast. How can the regulation keep up? Do you have any plans?
So we were really trying to avoid overregulation, and that we only really look into the high-risk cases, and that there is once a conformity assessment before it's being put on the market. I think this is the minimum legislation really also to create trust and to make sure that people can use the product, but also that they can develop them and know how to do it. So I think this is far from any overregulation. And we built in some mechanisms to have this dynamic, like that the list of use cases can be updated, that the type of conformity assessment can be updated, but also that what the AI definition, the technologies, the techniques behind that can be updated without a complicated legal procedure, but indeed with experts and member states.
Yes, thank you. I want to say thank you for the question that was from the anonymous person. But so just to understand, or to see if I understand it right, the regulation is not really on the technology itself, right? So even if technology is updated or moving fast, the regulation is not on the technology, but on the use case side.
Yeah.
Okay, yes, thank you.
Thank you for bringing up the question, Dan. Yeah, I missed it. So our time is up. It's 12:30. So Irina, thank you very much really for the exposition. It was very interesting for me. I hope it was equally interesting for the audience. Thank you for sharing time with us. And I do hope we follow up on this and are able to continue the conversation at another occasion. Thank you.
Thank you.